Hello, good afternoon, and welcome to our webinar, which has a very, very long title, but in fact simply deals with cyberbullying, uh, and in particular amongst learners in schools. This was initiated as a result of us coming across an article by Dr. Reddy, who is a senior lecturer at the University of Johannesburg and has extensive experience and knowledge about the topic. The issue of cyberbullying, there's been a number of reports and articles on it. But the difference with this particular webinar is that it provides you with an academic as well as legal as well as a practical lens through which to look at cyberbullying. With that introduction, my name is Adil Patel. I'm the head of the employment department and a member of the education sector at our firm, joined together with my colleague, Tim Fletcher, who is the chairperson of our firm, Anli Bezaidenhout, and Dr. Mohammed, who will be there just answering questions as you pop them on the chat group. Dr. Reddy has written an article on cyberbullying, and from a legal perspective, this is what we've experienced in private schools. So learners are, and in particular, as they reach sort of, and I usually say standard 9 or matric, and that just illustrates my age rather than anything else, but sort of grade 11 and grade 12, when there's some sort of freedom allowed to them. And what transpires is that they each provided with mobile phones, and they are managed to allow, or they begin to explore the sexualities and the like as such. Whole and behold, this then is distributed throughout. A particular example that's currently happening, or something similar, but not a learner, even amongst adults, you would see that's what's happening in the Puff Daddy court case in the United States, where he threatened a female, where it's alleged that he threatened a female with various videos and the like that she that was there as such. So what do you wish to take out from here today that you would not have taken out from any other facilitated session that you would have been on? We hope that today's session provides you with a different lens, a more academic lens, legal as well as a practical lens, in order to deal with the challenges you may find in schools on a daily basis as such. And what are your responsibilities as such? The other component is where teachers are being bullied as well through various platforms. What are the educators' rights as well? But lo and behold, let me hand over to Dr. Reddy to take us through the legal risk of cyberbullying in schools, and we'll then have our chairperson talking on PIDUPA and the like. Thank you, Dr. Reddy. Over to you. Thank you kindly.
Thank you so much, Adil, for that lovely introduction. As was mentioned by the facilitator, I am Dr. Reddy from the University of Johannesburg. I am a senior lecturer in the Department of Mercantile Law. I did do my doctorate in cyber law, but it was more on social media and cyber harassment, and it did touch on a bit of cyberbullying. So, as the facilitator did mention, I am going to look at the legal risks associated with cyberbullying. And how I wanted to really start off with, as way of an introduction, was looking at certain statistics. So, the first alarming statistic is that more than 95% of our children have access to the internet. Now, the key word is access. So it doesn't mean that they may have a mobile device at home, but it means they have access via other means. So that could be through a school computer, through the library, an internet cafe. It could be through, a tablet. There's so many different devices that we have now because of technology, such as smartwatches. You've even got a smart fridge that can communicate. You've got Apple and Android Play in your car. You've got, even now, I see Samsung has come out with a smart ring. So 95% of our kids have access to some sort of mobile or technological device that can connect to the internet. And in most cases, what I've noticed when I have presented and done research at other schools was that they often use devices that are given to them either by school or through school use or from their friends as well. The other alarming statistic is that more than 70% of our children are accessing the internet without parental knowledge. So parents either haven't given consent or they don't know that their kids are actually using the internet or have a device that can connect to the internet. Because of that, we've already seen more than 51% of children in schools have been subjected to cyberbullying. So that's quite a big number. 1 in 2 kids have been cyberbullied. And the interesting thing, I don't know how accurate it is, but one of the statistics did mention that girls are more likely to be victims of cyberbullying as well as more likely to be the perpetrators. So on both ends, they're more likely to be the bully as well as be the victim of bullying. Now, in terms of South Africa, we used to be the number one country in the world with the most cyberbullying cases. So, as usual, South Africa makes the news for, the wrong things. Fortunately, our South African relay team in athletics has done well, so we're making the news for other things. But we used to be number one, and now we have dropped, not by much, but we are still within the top 5 countries with the most cyberbullying cases in the world. So obviously, it does paint a very bad picture. When we look at a definition, there's no legislation that specifically applies to cyberbullying, which is a huge legal gap. And we then have to now look at what do we classify as cyberbullying. So from an education perspective, I have come to the conclusion that cyberbullying is repetitive conduct that is harmful and intentional towards another person, which is usually another child or student. And the intention is to cause harm to that student. So obviously it's done via electronic means, which would be the internet or social media. And the main thing in terms of harm is that the cyberbullying is aimed at causing harm towards someone's dignity, reputation. For example, it could be defamation, it could be hate speech, but anything that really is harmful towards the other person's feelings and dignity, that would classify as cyberbullying. And the reason why there was such an increase, I mean, cyberbullying has been around for quite a number of years, but recently it's really become prevalent. And that is directly attributed to the COVID-19 pandemic. We all know that when COVID-19 hit and the president said we were in a lockdown, all of us were forced to migrate online. And the schools had to quickly also get resources and use means to now educate online. And because of the online platforms, cyberbullying did see a big increase in terms of its use. A lot of cyberbullying done via Zoom, MS Teams, WhatsApp, any other online platform, there was a big increase in terms of cyberbullying in that regard. Now, because of the remote learning, we saw an escalation in these events, and therefore we needed to come up with a proper response. And then that now leads me to the effects of cyberbullying. So the main effect, it's very different to traditional bullying. Remember, with traditional bullying, our kids, if they were at school, they would get physically bullied, and then at least when they came home, they were very safe because they didn't have to face their bully. But now with cyberbullying, it's more of a 24/7 communication. So when your child or student is at home, they can still get cyberbullied because they have access to that electronic device, and the bully himself or herself can just send those communications repetitively. The other thing that has perpetuated cyberbullying is online anonymity. So a lot of users don't use their real name. They make up fake names, put up fake profile pictures, and then you don't know who the perpetrator is. And that creates more psychological harm because you don't know who it is that is perpetrating the cyberbullying. So it can have a very high emotional and psychological toll on the student because one, they're getting bullied 24/7, and two, they don't know who the cyberbully actually is. The other thing is because of the nature of social media and the internet, it is very easy to upload and post. You heard Adil talk about how students are given devices at a young age. And maybe it's because we live such a fast-paced life and technology has advanced so much that it's just easier for us to give our kids these devices. But those ease of communication, just creating an account and typing in information or uploading pictures, it makes it very easy to commit cyberbullying. And sometimes you may not be aware of the consequences as to what you are posting and who you are posting it to. Now, because of the ease of access and the way in which it can be spread, you've heard the term that posts can become viral. And that is where we've seen cases in terms of cyberbullying, which I'll touch on just now, where cases can become viral and the harm caused to the student can be very great and significant. And because we're looking at psychological and emotional harm, there are a lot of suicidal tendencies that victims usually experience. So, obviously, mental health issues, emotional trauma, we've even got self-harm that is a big issue. And in extreme cases, there can be suicide or attempted suicide. So, it's a very big issue and a very prevalent issue. And if it's untreated or we don't do anything, then the child can suffer long-term neurological or psychological harm from the abuse if it's left untreated. So this brings me now to the risk of not doing anything in terms of us as educators or schools. What can you do and what happens if you don't do something? And the best way I can really illustrate that is through one of our famous South African cases. It's a very unfortunate case of Lufuno Muvunga. So she was, I think, a grade 9 pupil who was physically assaulted by another pupil. And the perpetrator was actually encouraged by other students to hit the student and physically assault the student. Besides the physical bullying, the incident was actually recorded and uploaded to social media and it went viral. It was spread very quickly. And because of that, the student suffered a lot of psychological harm and it eventually led into her taking certain medication of which she overdosed and then she unfortunately passed away. And because of that, the school was brought under the spotlight. Apparently, she brought it to the attention of the teachers, nothing was done. And then the parents also brought it to the attention of the principal, and the principal didn't take any further steps in that regard. So, what happened was when the South African Human Rights Commission did their inquiry, they found that the school breached their duty of care. So, remember, as educators and teachers in the school, you have a duty of care to obviously look after the well-being of the learners in the school. It's not like the parents come to school and can look after their own children. There are difficulties in that because obviously the student-teacher ratio is very imbalanced because obviously the students outweigh the teachers. So you can't expect one teacher to oversee and really look out for 90 students. It becomes very difficult. But what the Lufuno case illustrates is that the issue was brought to the attention of the school, and the school did not take any appropriate action. And again, it's very difficult for the school. I do understand. I'm not saying the school was right in doing nothing, but you got to treat every case on a case by case basis. I know lawyers are very famous for saying we have to treat everything on a case by case basis, but it's true. There will be some times when the case is not serious or it's very trivial and it can be dealt with then and there. And there are other cases where it is more serious, where it does warrant a lot of action. So I think your duty of care is very important as a school. You stand in for the parents, and you have to make sure that if any disciplinary issues are brought to your attention, that you do take certain steps to mitigate any risk or to address the issue. And then that nicely brings me to my constitutional implications, which is Section 9 of the Constitution that looks at equality. So every learner is equal before the law. And what we mean by that is that no one should be discriminated against. When we looked at the definition, because it's so broad, cyberbullying can really look at hate speech, it can look at discriminatory conduct, it can look at defamation. There's various sorts of conduct that can fall under different areas of the law. And Section 9 of the Constitution is basically our equality clause that says you're not allowed to discriminate against anybody on sex, gender, race. There's a lot of listed grounds, but it can also be something that's unlisted. And the common ones that I've seen when I've talked to parents and teachers is that, my child has been bullied because they wear glasses, they look differently, or they've got two same-sex parents, and, they're being made fun of that you have two moms or you have two dads. And it's really there where the issues of discrimination come in. We then look at Section 10, which is our dignity, the
Really,
right
maybe if
to...
I could just, while you're there, just ask you this
Sure,
question.
sure.
So how does a parent or a teacher, and probably there's two parts to my question, identify what is a joke and what is actually cyberbullying? And then the second one is, as a educator, what sort of signs from your research should I be looking out for that should start raising concerns for me as an educator? If you could just deal with it from your research perspective and
Sure.
linking to just what you've spoken about. Thanks.
Perfect. Yeah, very, very important question. So, the first one, okay, let me deal with the second question first, because I think that ties in with the whole equality and discrimination and psychological issues. So, how do I know whether my child has been cyberbullied? What do I look out for? So, as I did mention, psychological harm is one of the biggest issues from cyberbullying. And you will know as the teacher or the parent, you see your child almost every day. As a parent, you see your child every day. For teachers, you'll see the child probably every day in school, except for the weekends. And you will notice a change in behavior. So psychological trauma or emotional trauma, you can see physical signs of any sickness or depression and anxiety. That are the big issues. For example, they stop eating, they start biting their nails, pulling out their hair, developing skin rashes because of the anxiety. If you've noticed, they've deleted their profiles from social media, change in moods, and sometimes the change in moods are a bit difficult to understand because parents say, oh, it's puberty or it's a change of an environment, and the change of moods is just adolescence. They brush it over. But really, your child, and the teachers really do know their students. So you would see certain behavioral changes. Maybe the child's become more aggressive or very quiet. The other common one in my research was, wetting the bed or insomnia, can't sleep. So I think that would be signs or indications that your student or your child has been cyberbullied. The first question that you asked in terms of a joke and cyberbullying. Now, it's very difficult to answer that question because of the mental maturity or the maturity of a child. Remember, we as adults, hopefully we can differentiate between a joke and what's wrong or unethical. And for children it becomes a bit more difficult because they all like to partake in pranks, or they do something without thinking about the consequences. And the real determining factor in deciding whether something amounts to cyberbullying is looking at the effect of the conduct. So really, it's an intention. And again, sometimes the child may not have an intention to cause harm, but the effect is harmful. And to me, that would still amount or constitute cyberbullying. but you're looking at, is it harmful? Is it, for example, I've uploaded one of the cases, famous cases in South Africa, was where two students altered a picture of the principal and vice principal, and they put the faces of the principals onto naked bodybuilders, and it was done as a joke. And obviously, as the person who's affected by that, you would see it not as a joke. So it may not have been their intention, or they may have done it as a prank, but the effect of that prank is harmful. So you're looking at, is the conduct actually harmful? And in my opinion, that would be a good indication as to whether or not that would amount to cyberbullying. And then that ties in where I was actually left off in terms of dignity. If you can prove that something affects your reputation, your good name, or your dignity, then that is also a very good indication that it could amount to cyberbullying. And then just two more from my side in terms of the Constitution. The other important right is the right to privacy, which has become very much important in terms of the digital age. People believe, social media is a public platform. So if you put something there, you don't have the right to privacy, and that's not necessarily true. The other way, conversely, to look at it, if I put something in a private WhatsApp group, it doesn't mean that the communication is private, because someone can always forward that or screenshot it and send it elsewhere. Yes, it could be an invasion of privacy, but WhatsApp is also a public communications tool, so it's not inherently just a private chat. So privacy is looking at, for example, the Lufuno case where they videoed her and put her on social media. There could have also been a breach of privacy. Someone sends you, and it's actually quite common. I know, Adil, you did mention that grade 11 and 12 learners have these devices, but in my experience, when I talk to public schools, the issue runs deep from grade 3 learners engaging in sexting, sending pictures. It's actually worse than we know. And I think those in the schooling environment have a better outlook and picture than we do, because they are actually involved in these cases. And then that just touches on.
Dr. Reddy, while you're there, let me just
Mm.
ask. So you would see, at least in some of the private schools, and I know that there's a worldwide thing happening at the moment, where they are attempting to have a situation where they're going to have school-free devices or devices. So what impact, or from based on your research, what do you think its impact is going to be on cyberbullying? Because they're looking at it purely from a productivity perspective and a concentration, because you do see, based on the health, the medical research, that there's increase on mental health challenges as a result of this. So can you then just say to me, or just explain what your view is, whether that's an effective measure in dealing with cyberbullying?
Yeah, so I think, UJ is also an example. When we went into the lockdown, we rolled out giving devices to our students so they could actually access the education platforms, and we could still deliver our lectures and communicate with the students. So I think it's a very fine balance between access to information and then, abusing that device for other purposes that it was not intended for. But I do agree with you that it is going to increase cyberbullying. There are ways in which you can manage it. So I'll touch on it later. It'll talk about monitoring certain platforms, and you can also disable access to certain services. But again, what is the main function of giving the student a device? And if you don't use that device according to what it was intended for, then yes, you're going to be found guilty or in breach of those rules. But I think I'm gonna stop here, and
Thank you.
I just want
Thank
to
you,
know,
Dr. Reddy.
yeah, if my colleagues want to take over. I do have a quick 2 minutes on other legal protections in terms of part two, but I'll hand it back to you to just
Thank you.
introduce part two.
Thank you, Dr. Reddy. Let me hand over to our chairperson, who has been a board member and an advisor to various private schools, but his most important job is to be the chairperson of our firm, and then as a litigator, experienced. Unlike me, doesn't have as many gray hairs, but he's wise in other ways as well. So he's going to talk to us about He's going to talk to us about cyberbullying in the context of the legal remedies that are available to both educators and learners and parents. Chairperson, thank you.
Thanks, Odile. The first act I'm going to talk about is the Protection from Harassment Act. And the idea of this act, which was passed in 2011, is to provide an easy way for somebody who is being harassed to get relief. And that act talks about harassment in a very broad way. And harassment is, I'm just going to read the definition, the top of the definition: directly or indirectly engaging in conduct that the respondent knows or ought to know causes harm or inspires the reasonable belief that harm may be caused to the complainant or amounts to sexual harassment. And the definition goes on, and it's quite broad. But the purpose of this act is to provide a very easy way for somebody to get help, and it requires the person to go to the magistrate's court. The clerk of the relevant magistrate's court will then assist the person, even if they are unrepresented, to get what is called a protection order. And the relevant magistrate's court, that is fairly broadly defined as well, because it can be the magistrate's court of the jurisdiction in which the complainant lives or works, or where the respondent lives or works, in other words, the perpetrator, or where the cause of action arose. So it could be, if you have a learner who lives in Bryanston, it would be the Randburg Magistrates Court. If the complainant lives in Alberton, it could also be the Alberton Magistrates Court. And if the school is situated in Kempton Park, it could also be the Kempton Park Magistrates Court. So the jurisdiction is defined as broadly as possible as well. And if a complainant goes to court and presents what is called a prima facie case, in other words, on the face of it, looking at the allegations that are made by the complainant, that there is in fact harassment taking place, then the court must issue a protection order, even though the other party doesn't know about the protection order. So they will issue what is an interim order with a return date. The order is then served on the perpetrator, the respondent, and the order becomes effective immediately it's served on the respondent. If the respondent arrives on the return date and doesn't convince the court that there isn't harassment happening, or doesn't arrive on the return date, then the order will be made final, and together with that order, a warrant of arrest will be issued for the perpetrator, and that warrant of arrest will then be suspended on condition that the perpetrator behaves themselves. So it's a fairly draconian remedy, but it's easily obtainable in circumstances where there is harassment. The other piece of legislation, Dr. Reddy mentioned Section 9 of the Constitution, and the Constitution requires the government to pass legislation to deal with the rights in the Bill of Rights and to flesh out those rights. So in 2000, there were a couple of those acts passed, and one of them was the promotion of equality and, sorry, let me just get the full name. It's generally known as PEPUDA, and then I forget what the full name is, the Promotion of Equality and Prevention of Unfair Discrimination Act. And that was passed in 2000, as I say, to flesh out the right to equality in terms of Section 9 of the Constitution. And what that act talks about is that nobody may harass another person and nobody may unfairly discriminate against another person. And unfair discrimination is any discrimination on one of the prohibited grounds which is unfair. And the complainant must first establish that there has been discrimination on one of the prohibited grounds. And those grounds are broad, and I'll read those as well: race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, and HIV/AIDS status, or, and this is the catch-all, any other ground where discrimination based on that other ground causes or perpetuates systemic disadvantage, undermines human dignity, or adversely affects the equal enjoyment of a person's rights and freedoms. And if you are able then as a complainant to establish that there is discrimination on one of those prohibited grounds, then the onus shifts and the respondent must then show that the discrimination was not unfair. If there is discrimination proved and it is proved to be unfair, then the court has the Equality Court now, which is any division of the High Court or a magistrate's court that is designated as an equality court, can then give various orders, including declaratory orders, orders for payment of damages, interdicts, ordering apologies, ordering payment to a charitable institution. So, for example, if you have done something, as I sit here, I now can't think of it. I can't think of an example, but rather than paying damages to the complainant, you may be ordered to pay damages to a charitable institution that looks after this kind of harm that is done to people. So the jurisdiction, the powers of an equality court are broad, and they also include referring the matter to the Director of Public Prosecutions if the court believes that there is actually a criminal offence that has been conducted.
Tim, can I just ask, so basically under that, insofar as a student, and we can have the debate, you and I, or I'm or Dr. Reddy for argument's sake, it's after school hours, and a student goes and records another student or cyberbullies another student after school hours. I gather that at least from an employment law, if I was just dealing with this from an employment law perspective, it's off-duty misconduct, you're acting against the school conduct, against the company's conduct, bringing the company into disrepute. I would still be able to discipline such an individual. But from first in terms of the PDUPA Act, whether you believe that the parent of the child who's been bullied has a claim against the bullier as such.
Absolutely. Under the PPUDA, if there is discrimination and it is unfair discrimination on one of the prohibited grounds, then there is certainly a claim against the bullier because they are discriminating. Whether there would be a claim against the school will very much depend on whether the school is somehow implicated. But if that conduct happens completely outside of the school and there's no connection, then I don't see how a claim against the school could be substantiated.
Dr. Reddy?
Yeah, if I can just jump in. So I think it's a very good question, and it's one that I get commonly asked. Mr. Fletcher is 100% correct. If you can prove that the cyberbullying causes a substantial disruption to schooling activities, then yes, the school has to do something about it. But if there's no disruption to schooling activities, or it's completely after hours, then it's the parents. Remember, at home the parents are still the guardians. They are supposed to supervise the child. But what can happen is if the cyberbullying affects the school and it can cause substantial disruptions to schooling activities, then yes, the school will be involved to intervene in that regard. So it's a very fine line. I mean, I know teachers are very tired because they're not at school, but they're still burdened by things that are happening outside schooling hours. But if it affects the school activities during schooling hours, it can have an effect because now students are talking about it, or it's been brought now into school and it's affecting students and teachers or parents. Then yes, the school can take action and will have to do something about it.
Let me just say from our side, just from a school perspective, what we've told schools, and Andy could probably just come in here, update your school code of conduct to say that sort of behavior will be taken seriously. But more importantly, what we've done as well is to say that insofar as your conduct outside school brings the school's name into disrepute, or you don't conduct yourself in accordance with the code of conduct or the values of the school, we may discipline you, suspend you, or even terminate your agreement. Anli?
That approach is very much supported by the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace, which is the very first document you would look at for anything relating to cyberbullying that's affecting your staff. And that also extends to clients, customers, service providers, essentially anyone that gets into contact with your employees or that may involve your employees in an element of harassment. That code, when it was introduced 2 years ago, also introduced the concept of cyberbullying and accepted that that can happen in a workplace and that can constitute harassment. So it places an obligation on you if the school's an employer, as it would always be, to take proactive steps to protect everyone that would enter the school premises and be in contact with its employees from harassment and from harassing those that are on the premises already. And I think what's important there is that it also extends to any work-related functions or activities. So the extension would apply to school trips, to after-hours activities, extramurals, parent-teacher evenings, bumping into each other in social settings. All of those interactions would still be covered by the code, and you would still be required to protect anyone that gets into contact with each other because of the workplace against harassment and all forms of bullying.
So only while you have the floor, and not many times we get to interrupt the chairperson, but maybe you just want to talk about the Code of Good Practice on harassment while you have the floor.
Sure. So the Code of Good Practice was, as I said, introduced 2 years ago. It requires you to adopt a policy against harassment. And I think what's important there for employers to note specifically, which would obviously include all schools, is that you have to adopt that policy against harassment generally, which would include cyberbullying. So where in the past we may have had policies relating to sexual harassment, we now often see in practice that those sexual harassment policies haven't actually been broadened to also deal with issues such as cyberbullying, etc. And it specifically acknowledges that harassment, which includes a form of bullying, can extend and can happen in all settings, but can also happen online. So any interactions. And it requires, if you read the definition of harassment and how broad it is, it also introduces to schools the requirement to review other policies, such as, for example, your social media policy, because those two speak to each other, right? Because you need to protect your employees, your clients, your customers against harassment, you also need to put certain protection measures in place, which in a school would be a social media policy, regulating how and if educators may interact with students or parents on social media at all. Apparent things that you would want to put in place, for example, is that certain privacy settings need to be in place, whether or not it's permitted to befriend or not, any interactions that happens on settings or any WhatsApp groups, for example. You may just want some broad guidelines to govern that, just because the interaction is happening in a much wider framework than just a classroom.
So can I just ask you, Anli, where teachers are bullying each other? So you would have seen in today's, where teachers are bullying each other. What are the school's obligations or rights there in terms of it, whether it's off duty or on duty sort of conduct as such?
So those two teachers would be in interaction with each other because they work at the same school, right? So that means that your jurisdiction, if I can use that word, to discipline would extend to them and to investigate. So the code places a positive obligation on you to look into that, to investigate it. You need to do that confidentially and sensitively, and it may be necessary to follow disciplinary process. The victim of harassment, which in other words would be the victim of bullying, and who raises any issue with the school, has the discretion to say whether or not they want to follow a formal or informal process, which essentially means, are they comfortable just for the perpetrator to be spoken to, or do they want disciplinary proceedings to follow if their complaint is found to be valid? I think what's important in that, though, is that the schools always retain the decision-making power about the ultimate process it wants to follow. In other words, if there's a serious matter of cyberbullying or bullying that comes to your attention as the school, then in most often, you would need to investigate fully, and a disciplinary inquiry would need to follow, whether that interaction happened on or off school premises, because the code is so wide and it protects your employees in all interactions.
Right. Thanks, Andy. And maybe just get Dr. Reddy to come in because that will lead nicely into his section. Dr. Reddy, what remedies are available then to schools and parents, and the issues of consent and the various sort of platforms that are available to individuals to access that? Thanks.
Yeah, no, thank you so much. And I think Anli has touched on an important point there, which is your code of conduct in the workplace, your social media policy is imperative. And that also ties in with your roles of disciplinary hearings in schools. So, in South Africa, we have very good laws, but sometimes we are impeded by enforcement, maybe due to lack of funding or other resources, or because it's just, very, like, our court system is sometimes backlogged. And the same thing with disciplinary hearings. They shouldn't just be a way as to deter people or as a warning factor. If an incident has occurred, that disciplinary process and that code of conduct should be implemented and followed. Otherwise, what's the point of having that social media policy or that code of conduct in school? So I think your code of conduct goes hand in hand with your execution of that, which would be through your disciplinary hearings, which is very important. And remember, the Lufuno case highlighted that when a case of bullying does come to the school's attention, they should take steps to make sure that they are adhering to the relevant policies and, having a disciplinary hearing if the case actually warrants a disciplinary hearing to happen. But moving on to remedies. So I didn't talk about it initially, but we do have a Cybercrimes Act. And one of the most important provisions deals with what we call malicious communications. And I think cyberbullying can fit under that, but the forms of conduct are a bit restrictive. So the one form in Section 14 deals with hate speech, so a threat of violence or damage to property or violence to a person. Section 15 is a direct threat of damage to someone or a direct threat of violence to an actual person. And then Section 16 is where someone publishes intimate images about someone else without their consent, which is commonly known as revenge pornography in South Africa. But I think that is a bit of a restrictive definition because I could just take a picture of you, digitally alter it and upload it, and it's not technically revenge pornography. It's just an intimate image uploaded. But be that as it may, the Cybercrimes Act deals with those certain forms of cyberbullying. And because it is a criminal statute, it advocates for certain criminal consequences or sanctions. And that is mainly a fine, or the maximum imprisonment would be 3 years. So if someone uploads, a picture of a teacher, they take a picture of her chest, or, and they put a phone under a desk and she sits down and they take a picture of that and they upload it, that would amount to a breach of the Cybercrimes Act. And that teacher can then pursue criminal avenues, which would be an imprisonment or a fine. The only issue with criminal sanctions is that we have to remember that if the perpetrator is a child, that you are dealing with a minor, so someone under the age of 18, and then the Child Justice Act does come into effect there. If it's a normal, employee who's over the age of 18, then it's fine. You can go straight for that criminal remedy. But the Child Justice Act really looks for restorative justice. So imprisonment is really a option of last resort. It doesn't mean that it can never happen, but we don't like to imprison the youth. We try to reintegrate them into society. But it is obviously, if it's a serious offense, such as a threat of violence, and kids can be a bit violent, like the teacher gave me homework, let's all kill the teacher, or whatever it is, a threat of violence, that could be perceived as something quite serious. And obviously, besides your disciplinary action, you can then rely on the Cybercrimes Act and advocate for imprisonment.
While you're touching on that, you would have seen in the recent past where teachers in both private and public schools were physically abused.
Yes.
Now, I'm not too concerned, well, for the purpose of this discussion, about the individuals who are actually doing the abusing, because there's various criminal remedies. What I'm
Yes.
concerned about is what is the impact on the person who actually takes the video. And you will recall SAA had a similar example. And now I've noticed that on airlines, when you go, they say, please do not take videos of our employees. And if you could just touch on that, please.
Yeah, sure. So we do have a social media charter that has been recently released by the South African Human Rights Commission. It's just a guiding document. It's not what we call hard law. So it's really soft law. It just provides guidance and recommendations. But according to that, and I think it's going to be a bit debatable, anybody else is more than welcome to come in here. But you, as a person who likes a comment that advocates for violence, or if you share that comment in support, if you tagged in it and you don't remove yourself, according to that social media charter, you can be held equally liable. So someone who also records the incident and doesn't stop it or doesn't report it, they can be held sort of as an accomplice. You can be held equally liable with the actual person who has committed that cyberbullying. And that is recently we are now coming in because, I mean, with retweeting or re-Xing, because it's now changed to X, sharing someone's post that is harmful, the law is now taking a stand to say that if you are in support or if you share or like that or you video it, you can also be held equally liable, even though you didn't commit the physical act of bullying or you didn't actually publish that statement. Then that ties in with my civil remedies, which is, if you look at defamation, which is the wrongful and intentional publication of defamatory material about someone else, that would allow a victim to claim personal damages. But sometimes defamation is quite difficult because if I'm sending you private messages and you're the only one who sees it, it's not defamation of character because your character can only be lessened if a third party sees that communication. So we have to rely on our normal civil action, which would be what we call a delict, and you have to prove those elements of a delict, which is sometimes a bit difficult because there's various elements to prove. But the main one, and I've seen a recent case that dealt with revenge pornography, where a ex-husband uploaded a secret video of his ex-wife, and he created a fake Facebook account, and he uploaded all these videos of her. And the court actually gave her 3.5 million rand in terms of general damages and special damages. So they use the actio injuriarum, which is part of our common law. It's just basically an action for damages for injury to personality. And then you've got an action for pain and suffering, which is due to emotional shock, such as trauma and anxiety. So they said because she had to go for counseling, not only in the past and now, but in the future, they awarded her 3.5 million rand damages. And I always ask people, do you think if I upload a video of you in an intimate manner, do you think 3.5 is enough to restore, your dignity? So it's always going to be, as I say, on a case-by-case basis. But for a teacher who has been subjected to cyberbullying, you can institute a personal action for damages, but the court will be the one to determine what is the appropriate amount in that case. And they'll look at, for example, how many people saw the post, who you are in society, how far did it spread. They'll take in a lot of factors and they will determine. You can't go and say, oh, there was a case that was 3.5 million and I won 3.5 million because, the case has set a precedent. It doesn't work like that. So in terms of civil remedies, you're really looking at emotional harm and then anxiety and emotional shock that can be caused by that cyberbullying.
I think that just in the last 10 minutes, maybe just to let me just give some concluding remarks and then the rest of the colleagues. I think from a practice perspective, what we're seeing within the education sector is the following. Part one is the bullying amongst learners. And what we are doing there, whether it's at school or outside of school, is we are disciplining the learners as such, especially where such conduct brings the organization to disrepute. 2 is where the cyberbullying is against teachers by students. We're disciplining the learners, and teachers are then allowed to institute a civil claim against the learners and or their parents. 3 is at times schools also act on behalf of the teachers, because schools have an obligation in terms of the Occupational Health and Safety Act to create a safe working environment. And that leads me to Ms. Willard's comment that you as a school have an obligation to create a safe working environment for your employees. And one of those safe working environments is to educate both your employees, those are the teachers, as well as learners and their parents about what is good device usage, what are their obligations and the like. And if you fail to do so, hypothetically, if a school fails to create a safe working environment, there's potentially an employment law claim against the school where the employee may say, you have failed to create a safe working environment, you have not taken issues of harassment seriously and the like, and you have exposed me to this sort of conduct as such. By way of example, in the employment context where an employee was beaten up by a trade union and she successfully instituted a civil claim against the school because they failed to create an environment that was safe for her. What then we have as well is where teachers are bullying their children or their learners as such, either sexually or otherwise, in order to undertake inappropriate acts. Obviously, from an employment context, the teacher may be disciplined. We must not forget, as Dr. Reddy has said, that also the parents have a role to play in instituting and exercising rights on behalf of the children. Now, having said that, all of this should be documented in a policy or in some document. But I think Ms. Willard has hit the nail on the head. What is most important from our side is one of education. And it's not education once off, it's constant reiteration of what it is and what are safe spaces and safe zones, but more importantly, what is the safe usage of devices within schools' environments. Those are my concluding remarks. Let me hand over to Anli, then to Dr. Reddy, and then to the chairperson to close. Thank you. Anli.
Anli, you're on mute.
Tim, I think there's a problem with Anli's computer. Do you want to just, sorry, Dr. Reddy, do you just want to come in and just give some concluding remarks? Thank you.
From my side, very quickly, I didn't touch on it, but in terms of the Protection of Personal Information Act, POPIA, if you have, for example, devices that you are rolling out to students, or if you're using platforms to teach, please make sure that you do draft or have rules that deal with terms of use, because that's going to be your saving grace. So when I talk about terms of use, you can say, for example, that you are recording those online sessions to make sure cyberbullying is not going to occur, or there are ways in which that we can identify students who are committing cyberbullying. But remember, in terms of POPIA, it needs to be a lawful processing of information, so you need to get their consent. And if you've got their consent and you specifying what the consent is going to be used, so what they are consenting to, so for example, you are consenting to for the school to collect the information, to monitor the chats, then it's done in a lawful manner and you will be allowed to do it. You will, save yourself in that regard. In terms of the education and awareness, this webinar, I think, is probably one of the most impactful. And I think from one of the big law firms in South Africa and in Africa, from Cliff Decker Hoffmeyer, it's going to be a very big impact in raising education and awareness. From my side, I'm very happy. I do give a lot of talks. So if you want me to, free of charge, buy me a chocolate, I'm happy. I'm more than happy to come to the school and speak to the kids. From my own personal experience, the teachers and the parents take it very seriously, but the students don't until they have been personally affected by cyberbullying. But obviously, if you just want to tick it off your list, I'm more than happy to give a 1 hour, half an hour talk to the kids on cyberbullying, on any specific areas that you want. But from my side, a big thank you to CDH for hosting such an important issue. And I hope you guys did gain some valuable, as Adil said, educational insight as well as legal insight from the talk.
Before I hand over to the chairperson, Dr. Reddy, please, you got to just tell them that we didn't pay you to say the last stuff, that we're a really good firm. Thank you. Chairperson.
Thanks. I just want to jump in on the last question there. Can the parents be held accountable by the school if the parents were aware of the cyberbullying but did not take any steps? Well, the school wouldn't be holding the parents accountable because the damage would be suffered by the child. So I think that's the answer to that question. The one thing that I think about when you listen to all of these various acts and rights and constitutions and things, that it must be extremely confusing and probably a little concerning for educators that you're now working in such a fraught environment. But the one thing that I think that you can rest assured, as strange as the law sometimes seems to be, most of the time it's logical. And if you think what will be logical, you will probably get to the right answer. If you're still struggling, please don't hesitate to just reach out to us. We're very happy to have a 5-minute chat and just give you some guidance. Obviously, if the matter gets more complicated and you do face an equality court claim, or you are considering bringing harassment claim or something like that, then we're very happy to get involved on a formal level. But certainly for a 5-minute advice which might put you on the right track, we're very happy to assist. And in closing, I hope that you enjoyed the webinar.
Thank you all, and you've got our details. Thank you, Tim. And please look out for more of these and send it to your colleagues at other schools. And we hope you have a pleasant Wednesday afternoon. Thank you for joining us. Cheers.